Hello everyone, welcome to the 160 Literary and Jury Charge. We're going to start off today with some Latin and French words, and I will give you the words and then read the paragraph, and then we'll go back. I'll give you the word again and spell it so you can put it in your dictionary at a later time. Okay, so first we have mandamus, then we've got guardian ad litem, mens rea, and carpe diem. All right, so here is your paragraph. Ready? A guardian ad litem is a person designated by the court to conduct litigation on behalf of another. A guardian ad litem usually represents a minor. Mandamus means to command. A writ of mandamus is issued by a higher court commanding specific action by a lower court. Mens rea is sometimes described as the guilty mind. When a person has criminal intent, he has mens rea. A guardian ad litem is normally appointed for the duration of the trial. A writ of mandamus may be issued to a non-judicial official. Carpe diem means to take advantage of today and place no trust in the future. Carpe diem literally means to seize the day. Okay, so let me say these again and I'll spell them for you. So we have guardian ad litem, Guardian space AD space LITEM, mandamus, MANDAMUS, mens rea, MENS space REA, and carpe diem, CARPE space DIEM. I'm sure you've heard of those in your legal class, but it's always great practice, and if you don't have those already in your dictionary, you want to be sure and put those in so they show up when you come across that word. Okay, so I've got a selection here from Don't Sweat the Small Stuff. This is called Life is a Test. It is only a test. Here we go. Ready? One of my favorite posters says, "Life is a test. It is only a test." Had this been a real life, you would have been instructed where to go and what to do. Whenever I think of this humorous bit of wisdom, it reminds me not to take my life so seriously. When you look at life and its many challenges as a test or series of tests, you begin to see each issue you face as an opportunity to grow, a chance to roll with the punches. Whether you're being bombarded with problems, responsibilities, even insurmountable hurdles, when looking or looked at as a test, you always have a chance to succeed in the sense of rising above that which is challenging you. If, on the other hand, you see each new issue you face as a serious battle that must be won in order to survive, you're probably in for a very rocky journey. The only time you're likely to be happy is when everything is working out just right. And we all know how often that happens. As an experiment, see if you can apply this idea to something you are forced to deal with. Perhaps you have a difficult teenager or a demanding boss. See if you can redefine the issue you face from being a problem to being a test. Rather than struggling with your issue, see if there is something you can learn from it. Ask yourself, why is this issue in my life? What would it mean and what would be involved to rise above it? Could I possibly look at this issue any differently? Can I see it as a test of some kind? If you give this strategy a try, you may be surprised at your changed responses. For example, I used to struggle a great deal over the issue of my perception of not having enough time. I would rush around trying to get everything done. I blamed my schedule, my family, my circumstances, and anything else I could think of for my plight. Then it dawned on me, if I wanted to be happy, my goal didn't necessarily have to be to organize my life perfectly so that I had more time, but rather to see whether I could get to the point where I felt it was okay that I couldn't get everything done that I must or that I felt I must. In other words, my real challenge was to see my struggle as a test. Seeing this issue as a test ultimately helped me to cope with with one of my biggest personal frustrations. I still struggle now and then about my perceived lack of time, but less than I used to. It has become far more acceptable to me to accept things as they are. I love this little book. This is from Don't Sweat the Small Stuff, and it's all small stuff. Simple ways to keep the little things from taking over your life. So, it's one of my favorite books. Okay, I'm going to read some jury instructions to you. Here we go. Ready? This will be at 160. All right. Ladies and gentlemen, before the trial begins, there are certain instructions you should better have to understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented and the law given to you by the court. Do not let any personal feelings of bias or prejudice against any such things as race, religion, sex, or age affect your deliberations. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Should you be exposed to any reports or communications from any source concerning the case during the trial, you should report that information to the jury bailiff. The court is aware that many of you have been exposed to publicity concerning this case before you were selected to serve as a juror. Each of you has committed to base your verdict only on the evidence introduced during the trial. It is of vital importance to the parties and the sanctity of the court process that you remain true to this commitment. Anything you may see or hear outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received. And third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during deliberations. Otherwise, keep them confidential. Your notes will be collected by the jury bailiff after each day's session and kept in a secure place until the next day of trial. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You may ask to have specific portions of the testimony read to you. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. To assist you in evaluating the evidence, I will now read to you portions of the specific jury instructions for the offenses with which the defendant is charged. I will read them to you in their entirety at the close of the evidence. Count 1. Count 1 of the information charges the defendant with first-degree intentional homicide as party to the crime. Section 939.05 of the Wisconsin Criminal Code provide that whoever is concerned in the commission of a crime is a party to that crime and may be convicted of that crime, although that person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of first-degree intentional homicide by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime as well as the person who directly committed it. A person intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet the crime of first-degree intentional homicide, the defendant must know that another person is committing or intends to commit the crime of first-degree intentional homicide and have the purpose to assist the commission of that crime. Before you may find the defendant guilty of first-degree intentional homicide as a party to the crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of first-degree intentional homicide or intentionally aided and abetted the commission of that crime. All 12 jurors do not have to agree on whether the defendant directly committed the crime of first-degree intentional homicide or aided and abetted the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of those ways. Okay, so we'll stop there. I have a few briefs I want to give you that we came across when I was reading Beyond a Reasonable Doubt. That's either written two different ways, either YARD, Y-A-R-D, which that means if you use that you have to flag YARD, or you can write it as Y, final R-D, and leave out the A. That comes up quite a bit, Beyond a Reasonable Doubt, so you probably want to learn that phrase if you don't use it. And let's see. Oh, I like to phrase all the. That comes up quite a bit, all the. I write that as A-U-L-T. From time to time came up, F-R-I-M-T. Cross-examination, K-R-O-B-G-S. Verdict, V-E-R-D. Bailiff, B-L-I-F, bliff. Those are the ones that I saw as I was reading. Okay. All right. Moving right into fun facts. This is called a random origin, and this is on curves. Okay, the gym curves. Here we go. Ready? Gary Heaven ran a chain of gyms in Texas in the 1970s, but it went bankrupt. A few years later, Heaven started over, but this time he decided to focus on a different market. Women in their 40s and 50s had told him that they didn't like gyms because they were intimidating, filled with ogling men and younger women who were already fit. So in 1992, Mr. Heaven and his wife Diane opened the first curves for women in Harlingen, Texas. Only women could join, and it offered only one fitness plan created by Heaven. A customer rotates around exercise stations such as a treadmill, bike, stretches, weights, etc., switching out every 30 seconds. 3 circuits of all the stations total a 30-minute workout. Today, there are more than 10,000 curve locations. Interesting fact. Again, I did say the phrase all the, so there you go. You can write that as A-U-L-T. And then if I ever have the word alt, I just use A-L-T. Anything that starts with alt, like alternator or anything like that. Okay, moving right along. Got some medical for you. This is on bypass surgery after 80. All right, here we go. Ready? Coronary artery bypass graft, known as CABG surgery, is often not considered for elderly people with coronary disease because of their risk for serious complications. However, there may be few or no alternatives to CABG for patients whose angina symptoms cannot be controlled with medications. Even though the risks of CABG are high in the elderly, the outlook may be even worse if surgery is not performed. Researchers at Duke University, a major cardiac surgery center, recently reviewed the outcomes of all 86 patients aged 80 through 93 years who underwent CABG there from 2009 to 2011. Most of these operations were performed upon people who were desperately ill. 27% had had a heart attack in the last month, and 84% had angina at rest or during only mild activity. The majority of the patients were taken directly to the operating room from the coronary care unit or cardiac catheterization laboratory because they were too unstable to wait for CABG to be performed electively. These data indicated that most of these procedures were undertaken as a last resort measure. Serious complications occurred in 29% of the patients, and 14% died during the hospitalization. In contrast, the mortality from CABG surgery in younger patients is under 2% at many medical centers. However, 86% of these very elderly patients survived the surgery and quality of life improved dramatically. In general, these patients were too sick to be at home before surgery, but 66 or 89% of the 74 survivors went directly home from the hospital, while the other 8 survivors went to nursing facilities. Those at home were able to care for most of their own personal needs. Women were more likely than men to survive the operation, and to have good outcomes. Interesting facts there. All right, and that concludes our jury charge and literary for the 160 class. Have a great day.